Next, we'll talk a little bit about courts and corrections and how we've responded to youth in conflict with the law. So the three grounds for remand or pretrial detention. The primary ground, as I mentioned, is to ensure attendance in court. The secondary ground is to prevent future crimes against or have contact with the victim. And the tertiary ground is if the other two grounds fail. So if you're Crown Counsel and you can't justify detention on primary or secondary grounds, you would say that if we release this person into the community on bail, it's going to bring the criminal justice system into disrepute. Basically, the public is going to lose faith in the justice system. And if we do so, then the system is going to fall apart. So the person, if they've committed a really horrific offense, they should be detained regardless of the primary, secondary ground. So that's one of the roles of Crown Counsel, is sort of determining whether an individual should be released on bail or remanded. So they play an important role in charge screening, looking at police officers' will say statements to see if there is sufficient evidence to secure a conviction. And if it does seem like the person is guilty of an offense, deciding then, well, should we proceed with an extrajudicial sanction or formal court processing? So what I mean by that is, if the Crown Counsel thinks that an extrajudicial sanction is appropriate, then they want to keep the youth out of the formal system and not actually go before a judge. If the youth is before a judge, judge's role is basically to kind of look through information and make sense of the context of the young person. So they receive a lot of different sources of information. One is a pre-sentence report that's going to include information about the young person's past criminal history, their attitude towards the current offense, their family history, their educational history, their history of substance use. Typically also includes a psych assessment. It's going to be typically completed by a forensic psychologist that might describe their mental health needs. If they're an Indigenous person, they should also be receiving a GLADU report. So these are all these different sources of information the judge needs to consider to make decisions about the appropriate, whether it's a custody sentence and its length, or whether they should be sentenced to a community-based sentence, or whether they should be sentenced as an adult rather as a youth. On that note, when the YCJA was first introduced, it had a specific role for presumptive offenses. So presumptive offenses are particularly serious offenses. And so the YCJA said that if a youth 14 or older is found guilty of certain serious or violent offenses, then they will receive an adult sentence. So the idea is right in the word presumptive. It's coming from the presumption order. You're going to presume that this person deserves an adult sentence. And so the onus is on defense counsel to show on the balance of probabilities that the individual should not be sentenced as an adult. So it's what we would call a reverse onus clause. The onus is on the defense counsel to show why a youth should not be sentenced as an adult. This lasted for about 4 years until the case of R versus DB. In 2007, it said, no, this is against this individual's Charter of Rights and Freedoms, Section 7, so we are going to get rid of these presumptive offenses. Well, more specifically, we're going to get rid of the reverse onus clause. You can still have individuals sentenced as an adult, but the onus is on the Crown Counsel to show on the balance of probabilities that this should be done. So I'm not going to ask you about specific cases and what happened. Instead, I'm going to ask you to tell me as much as you know about your favorite case that we've talked about under the YCJA, or the case that you found most interesting and most relevant. When a judge is sentencing a youth to custody, there are actually 3 types of custody sentences that they can receive. There's a community-based custody sentence. So they receive custody, but they serve their custody sentence in the community. That's called a deferred custody and supervision order. Then they have their custody and community supervision order, where they serve 2/3 of their sentence in custody. They serve 1/3 of their custody sentence in the community, and they typically follow that up with a period of probation. Another option is the Intensive Rehabilitative Custody and Community Supervision Order, or IRCS. And there are specific conditions in which an IRCS order can be ordered. On the topic of programming, we have to think about the fact that youth have different programming needs compared to adults. And a lot of this relates to the fact that they just have less mature judgment. They're more likely to be influenced by their peers. They are less likely to think about long-term consequences. They have poor executive functioning. So they don't reason and plan as well as adults. So all of these things are things to work on for youth, because we can see a really dramatic change in, for example, maturity of judgment as kids transition from adolescence to adulthood. So we might want programs that are going to really help ensure that these improvements do take place, because these improvements happen for everybody. Every adolescent, as they enter adulthood, typically will become better at seeing the long-term consequences of their behavior, less influenced by their immediate desires. So these programs are there to help make sure that these transitions take place. Mark Lipsy's 2009 meta-analysis helped us make sense of which interventions are most useful. So we talked about 6, and you'll see negative numbers here and positive numbers. Negative numbers indicate that had a reduction in the probability of recidivism or the rate of recidivism, whereas the positive numbers indicate that particular type of intervention increased the likelihood of recidivism. And so for each of these types of programs, you should kind of have an understanding of how they work. Surveillance is sort of like monitoring, having more intensive probation conditions. Deterrence is more punitive, thinking about doing things like scared straight programs. Discipline is more about like boot camps, wilderness training programs, so you can see that those have not been particularly effective. Whereas restorative justice programs, counseling, and skill building programs have all been relatively effective in reducing the likelihood of recidivism.